Welcome to today's program titled Developments in EEOC Enforcement in Fiscal Year 2024. At this time, all participants are in a listen-only mode. For those of you who are logged into the live web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chris DeGroff. Chris, please go ahead.
Thanks, Kate. Good morning or afternoon, depending on your time zone, and thank you all for attending. My name is Chris DeGroff. I am a partner in our Chicago office, although I'm calling from blustery Boston today. I'm co-chair of our Complex Discrimination Litigation Practice Group, and I'm really excited for today's presentation. The title suggests we're going to be looking back at fiscal year 2024, but this presentation is really about what 2025 has to hold for everyone with EEOC enforcement. Before we begin, our team wanted to dedicate this time together to David Rowland. David Rowland was a partner in our Chicago office and passed away last week. Dave was a gentleman and a complex litigator, a mentor and a dear friend to everybody on this call. So this one's for you, Dave. With that, today is going to be a meet the press kind of format with our moderator asking our panel some questions, but today you have a chance to also add questions in the question and answer field. So we'll try to get to those as we go along. If we don't, we'll reach out to you after the presentation. So with no further ado, I'm going to pass it over to our moderator, James Nasiri.
All right, thanks so much, Chris. Happy to be here. I want to introduce two of our other speakers today. First, we have Andy Scroggins. Andy is a partner in the Chicago office and the co-chair of the firm's Complex Discrimination Litigation Practice Group. Andy is also the co-editor of this year's EEOC-initiated litigation report. A significant portion of Andy's practice includes matters concerning the EEOC, ranging from the handling of administrative charges to systemic investigations, subpoena enforcement proceedings, and pattern and practice litigation. We're also joined today by Sam Brooks. Sam is an associate in our Washington, D.C. office. She's also a contributor to this year's EEOC report and a member of the firm's Complex Discrimination Litigation Group. Sam's practice focuses on the defense of both single plaintiff and complex discrimination cases, including EEOC matters. Now, Chris, to get us started, can you tell us what we're going to be talking about today?
Of course, and so everyone knows who you are. James Nasiri is one of our complex litigators in our Chicago office and works with all of us on the team, and a fabulous lawyer and author in his own right. Next slide, please. We're going to be talking today about all things EEOC, in particular the EEOC's lineup, which is an extremely hot topic and volatile topic right now. We'll be looking at charge data, litigation data, and an analysis of how cases are resolved. We'll be talking about the EEOC's strategic enforcement priorities and emerging issues and things that we predict we will see in 2025. Why is this all important? The EEOC just made an announcement this week that they are still very much open for business. and also, wherever the EEOC goes, the private plaintiffs bar follows. So even if you are not one of the unfortunate few tapped in EEOC litigation, private attorneys also follow that trail they blaze. So could we go to the next, yes, there we go. Andy, why don't you set us up with the commissioners?
Sure. So when the commission is fully staffed, we would have 5 commissioners. We would have 3 from one party and 2 from the other party, and we would have a general counsel. And among that group, they would make the most significant decisions about how the EEOC conducts business. As we came into this fiscal year, there was a vacancy on the commission, but there were 3 Democratic appointees and 1 Republican appointee. And then we also had a Democratic appointee as the general counsel. As often happens when there's a change in administration, the Trump administration made the sole Republican on the commission the acting chair. That's Andrea Lucas. But in a significant change from past practice, rather than letting these appointments by the commissioners run their normal 5-year course, which would mean that there would not be a Republican majority until at the earliest July of 2026. Instead, the Trump administration removed 2 of the commissioners from their seats, those being the former chair, Charlotte Burrows, and Jocelyn Samuels. That had a couple of impacts. One is that obviously it meant that there was no longer a Democratic majority on the commission, and so changed how decisions might be made or what kinds of decisions would be approved, but it also took away the quorum that the EEOC needs in order to conduct its business. They need to have at least 3 commissioners in order to make the most significant kinds of decisions. And so with just 2, it does hobble what the EEOC is able to do at this time. In addition, the administration terminated General Counsel Carla Gilbride. By statute, her deputy then became the acting general counsel for the agency, but just this week, he was put back into his role as deputy general counsel, and an acting general counsel was appointed by the Trump White House, Andrew Rogers. Andrew Rogers previously had been the general counsel to now acting chair Andrea Lucas in her role as a commissioner, then briefly was made her chief of staff, and then obviously now is in the seat of general counsel. Chris, do you want to talk about the responsibilities of commissioners and general counsel?
Sure. There is a complicated delegation of power within the organization. Without the quorum, as Andy mentioned, the commission is prevented from bringing some of their more large-scale litigation. But what we want to make sure that our audience understands is the EEOC still has and does operate through much of its regional leadership. The individuals out in the field, these are career EEOC lawyers and investigators, are still actively pursuing cases, still actively processing charges. So in the short term, even though certain types of litigation might be slowed, the actual processing of the sorts of things that you all are most likely to see continue relatively business as usual, except for what we'll be bringing up a little bit later.
All right.
Next slide.
Well, thanks, Andy and Chris. Those were some really timely insights as we grapple with what the EEOC is going to look like under a new administration. As we shift to some key EEOC numbers, we're going to start our by the numbers analysis by looking at the EEOC's charge data. This data is particularly interesting because it's a direct reflection of how American workers feel they're being treated and is not influenced by any political changes happening at the EEOC. So Sam, can you tell us about the types of charges that have recently been filed with the Commission?
Yes, of course. Thanks, James. So retaliation is consistently the most common allegation in EEOC charges, outpacing the next most popular categories, which are typically disability discrimination or harassment, by 10,000 charges per year. But notably, in fiscal year 23, retaliation outpaced the next categories, which were harassment, disability discrimination, and race discrimination, by 15,000 charges, and accounted for 56% of all charges filed. With regard to religion, in fiscal year 22, workers filed an all-time high of 13,814 charges regarding religious discrimination. Likely, that was the result of challenges to COVID vaccination policies based on religion. In fiscal year 23, however, the number of religious charges dropped to only 4,341. And we think that significant drop is due to the easing of COVID-19 vaccination requirements and the lapsing of statutes of limitations related to the denials of requests for religious exemptions from COVID-19 vaccination policies. A note about sex discrimination charges in particular, as you can see on the chart, there has been a steady increase in sex discrimination charges year over year in filings. But considering Acting Chair Lucas's recent statement about returning to the agency's mission of protecting women, removing the ex-gender marker from charges, and removing materials regarding LGBTQI plus worker protections from the EEOC website, looking ahead, we can expect an even smaller number of charges based on sexual orientation and gender identity discrimination. But the truth is we don't expect a material difference for employers because the number of these such charges was already small. And one final note about our chart, you can see pretty clearly that disability harassment and race discrimination charges have been pretty consistent over the last few years with a slight increase year over year.
And
James?
To jump in on, the data as we look ahead, we don't yet have this exact claim-by-claim breakdown for fiscal year 2024, but we do have the overall numbers. And the EEOC recently released that they received over 88,000 total charges of discrimination in 2024. This is almost a 10% year-over-year increase and the highest number of charges that the Commission has received since 2016 when they received over 91,000 charges. This increase that we're seeing also aligns with the EEOC's latest annual performance report, which touted increases in intake calls and intake activity. While we are seeing a kind of upward trend of increasing activity, at least in terms of charges, it'll be interesting to see, per Sam's point, whether that trend continues in light of the latest changes at the Commission. Next slide, please.
So before we move on, James, just a little bit of inside baseball, too. Part of the reason for that increase in charge numbers is likely the efforts of the former chair. What we heard from people with contacts within the EEOC is that she was encouraging the field offices to really follow up on any expression of interest in filing a charge that they may have received from employees. And so there was a real concerted effort on her part to drive up those charge numbers. And it remains to be seen whether we will see that same kind of push out of the newly constituted EEOC. I think it seems unlikely, though.
Just if I could jump in on that too, the acting chair does have the power to speed up and slow down certain processing and certain funding to the field. So acting chair Lucas does have some significant authority there. And last week we saw an announcement from the EEOC that sexual orientation and gender status charges are all going to be raised with Chair Lucas. So what that means in terms of EEOC processing, we don't know yet. But also announced just within the last 48 hours was an EEOC message that right to sues will still be issued, charges will still be accepted. So I raise that just to say there might be some steering, but the overall process still remains intact.
Very interesting. Well, thank you both for those insider thoughts. So as we continue moving to our next slide into our analysis of EEOC charge data, we have on the screen our breakdown of where these charges are coming from. And Sam, can you start us off by telling us whether we're seeing any trends in where recent charges have been filed?
Yeah, sure thing. There are certainly geographic hotspots where employees consistently file the most charges, and Texas employees lead the way and consistently do year over year, this year with more than 8,200 charges. Texas is followed by Florida, which had more than 6,200 charges, and Georgia is not far behind with more than 5,700. California, Pennsylvania, and Illinois take the 4th, 5th, and 6th spots in our top 10 list, followed by New York, North Carolina, Tennessee, and Ohio rounds out the top 10. But what's interesting is when you break that down further based on relative to state population.
Yeah, absolutely. So as we look at the other map on the slide with the slightly darker orange shading to it, this is our map adjusted for state population. And here, the southeast region of the country really pops as you see Georgia leading the way as they received over 5 EEOC charges per 10,000 residents living in the state. Other notable states in our per capita analysis were Arkansas, Tennessee, Mississippi, and Nevada. An interesting point here is that the EEOC puts out a year-end press release explaining their activities and highlights throughout the year. This press release called out the Commission's geographic diversity, which it described as heightening activity in rural areas and areas of the country that are separated from EEOC regional offices. And this point about geographic diversity was also echoed when we looked at the annual performance report, since there the Commission again emphasized outreach efforts to rural workers and folks who are geographically removed from a local EEOC office. Later in the presentation, as Chris noted, we'll break down the Commission's strategic enforcement priorities, but as a preview, one of those priorities is protecting vulnerable workers. And here, our impression based on the EEOC's filing and charge activity, as well as its notable outreach efforts to rural workers, signify to us that these folks separated from EEOC offices in rural areas have become a significant group within the vulnerable workers category. Now, next slide, please, Kate. We've heard about some highlights from the EEOC's charge data, but Chris, can you explain what the numbers are telling us in terms of litigation filed by the Commission?
Sure. This is to answer the question, when does the EEOC file lawsuits? We'll be talking about the what kind and why later in the presentation. But as you can see from this slide, traditionally, the EEOC has filed more lawsuits in the last month of their fiscal year than often the entire year put together. The EEOC sometimes denies that there is such a surge, but as you can see, the numbers don't lie. This year will be a fascinating study in seeing whether this trend continues to hold. And Andy, we're already starting to see some deviations from the pattern we see here, right?
Yeah, you can look at the chart and see that in most years, there are just, 1, 2, 3 complaints in January. It's very, very light. We saw a significant departure from that this year. There were actually 15 complaints filed by the EEOC, merits complaints by the EEOC, filed in January. Almost all of those coming before the change in administration, a few straggling in a few days later. And so, you don't have to read the tea leaves very hard to guess that they were trying to get some of those complaints on file before there was a change in leadership and presumably more resistance to filing those complaints in court. Since that time, we've seen things get a little more quiet other than some of the more routine matters like subpoena enforcement issues, the kinds of things that the regional offices need just to conduct their day-to-day investigations. But it was an unusual spike in activity in January, and it will be interesting to see now. It will probably take several months to figure out what pattern we might expect from this EEOC, since we're going into what is normally a pretty quiet period anyway.
Interesting. Thanks, Andy. So if we could flip to the next slide, we're continuing with the litigation numbers from the commission. Sam, when we look at the specific types of claims being filed, what were the most common allegations alleged by the EEOC this past year?
Well, as we can see on the chart on the slide, Title VII leads the way. But what I think is particularly interesting is despite the overall decrease in lawsuits from 24 to 23, so there were 111 filings in fiscal year 24 as compared to 144 in fiscal year 23. When considered on a percentage basis, the distribution of cases filed by statute actually remained pretty consistent. So Title VII once again made up the majority of the cases filed, accounting for 68% of all filings, which is on par with the last 2 years, likely because there are so many protected categories under the law. The ADA cases also made up a significant percentage on the EEOC filings, totaling 37% this fiscal year, which again is on par with the last 3 years. Age discrimination filings declined slightly with 7 filings as compared with 13, 7, and 1 in the last 3 fiscal years. But there was an increase in PDA and PWFA suits filed, mostly because the law was only recently in effect. And the EEOC has identified the PWFA as an emerging and developing issue. So we do expect to see possibly more in the next year. With respect to EEO1 report-related litigation, the EEOC filed 18 suits for noncompliance with EEO1 Component 1 workforce demographic reports. But Andy, what are your thoughts on likely changes coming?
Yeah, I think that's a pattern we're unlikely to see repeated. It was already an unusual spike in that type of enforcement that we saw in fiscal year 2024. I don't think we'll see the same kind of interest in pursuing those cases from this current commission. And it was really, I think, intended as sort of a warning shot to employers that they needed to comply with the EEO1 requirements, a message that they felt they needed to get out last year across the country. That message has been sent, and now I think it will be de-emphasized as we go forward.
Thank you both for that breakdown. And as we look at these litigation numbers, a point that Chris and Andy made before comes to mind in that, you know, while there are pending changes happening under the Trump administration at the EEOC, it's important to keep in mind that much of the commission's day-to-day activities, such as pending litigation and routine investigations, will continue to be led by the same regional attorneys who have led and litigated most of these cases we've analyzed on the screen. Next slide, please. So, Sam, looking at this regional breakdown, are there any notable trends in terms of where the EEOC is filing its lawsuits?
Yes, there sure are. And as Chris mentioned a short time ago, much of the litigation activity at the EEOC is really in the district offices. And again, there are lots of cases that the EEOC can bring without the vote of the full commission. So the lack of a quorum will not have any impact whatsoever on that. But particularly given the uncertainty at the EEOC, it is important to be aware of your particular region's litigation posture and proclivities. So notably this fiscal year and continuing from the last fiscal year is the prominent levels of litigation activity by the Commission's East Coast district offices. Philadelphia again led the way with a total of 16 lawsuits filed, outpacing the next closest district offices, Atlanta and Indianapolis, by 4 filings. And Atlanta and Indianapolis inched ahead of Chicago, which was last year's second highest filer, and Phoenix, who each filed 10 lawsuits. Other active districts on the East Coast include New York, who filed 9 suits, down from 1 last year, Charlotte, who filed 8 lawsuits, down from 1 last year, and Houston with 8 filings, and Miami also with 8 filings. Conversely, though, the Commission's West Coast district offices were again relatively quiet this fiscal year, with the LA and San Francisco offices combining for only 10 total filings this year. Chris, what do you think about that?
Uh, it's we've often said that when you're dealing with the EOC, it's all location, 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 right? And we had a very astute question from one of our attendees: is there any likelihood that the regional leadership will just start gutting their own staff? I think it would be very unlikely that we're going to see any of that. The regional leadership have been, some of these attorneys have been there for as long as I've been practicing, right? And that's a long time, over 25 years. And folks like Mary Jo O'Neill in Phoenix and Deborah Lawrence in Philadelphia will vigorously protect their staff. And regardless of what the orders are coming out of DC, I think we can still expect certain areas like Chicago, New York to continue to push very hard on their litigation agendas. Remember, each of these districts has its own personality, has its own resources, it has its own regional enforcement plans. So while we hear a lot of what's coming out of DC, it's still, and Sam, you were spot on that you've got to be very dialed in to the region where a charge is being processed and where litigation is being considered. So I think at least short term, especially with no quorum, we're not going to see dramatic shifts as in the regional personalities. Now, one thing that could happen is we could start seeing President Trump try to displace some of this regional leadership as well. We've heard no hints of that. That's pure speculation, but it is a possibility given what we've seen so far when commissioners that have actual statutory terms are being ousted.
Absolutely. Yes, it's interesting to see, this emphasis on not only geographic diversity, but the regional attorneys, playing up their own strategic playbooks. That certainly keeps employers on their toes around the country, whether you're in a major market or in a more rural area. We could move to the next slide, please. So at this point in the presentation, we've discussed both EEOC charge data and the types of litigation typically filed by the EEOC. But as we look ahead in these cases that are filed, Andy and Chris, can you tell us how these cases typically resolve?
Sure. There's only a handful of resolution tools. One, I'll just take off the table right away, which is the employer wins on summary judgment or on a motion to dismiss, right? So a defense judgment. Okay, that's one way to resolve it, and that's our preferred way of resolving these cases that are brought against our clients. But the majority of these cases go away through one of the following. For those who have not had the pleasure of tangling with the EEOC in negotiations, before a lawsuit is filed, there is an opportunity to settle, and it's a statutory requirement that the EEOC must conciliate a case. Now, under statute, this has to be a confidential process unless you give the EEOC permission to make it public, which the EEOC has and often does request. The answer is almost always absolutely not. That's the whole reason why we're having this conversation right now, is because we want to keep it confidential. But these are settlement negotiations that involve both monetary relief for the alleged victims of the problem and also non-monetary relief. We have a section in our book on a lot of these terms, and I invite you all to take a look at that if you want to do a deeper dive. But they usually constitute things like training, a review of policies, certain reporting requirements, notice postings, and there's a laundry list of different non-monetary terms that are involved in conciliation. Under the first Trump administration, there were strict employer-friendly guidelines on what conciliation was supposed to look like. For those folks on this call that have gone through conciliation with the EEOC, they understand it's like hitting your head against a cinder block wall. They're trying to get the EEOC to share information, to answer the question, why is training important for our Portland office when the the alleged behavior happened in New York, those questions went unanswered. But under the first Trump administration, there was a more show your work directive. That was immediately dialed back under the Biden administration. I think that once the dust settles on the bigger picture things that are happening in the government right now, this might be another, these ideas of more show your work in conciliation will come back. If you do not resolve the case in conciliation and the EEOC does choose to move forward with litigation on its own behalf, then we have what's called a consent decree is the only way of resolving the case. Once the lawsuit is filed, this is the only instrument. Now, folks often say, well, they don't have to have it that way. No, the EEOC, this is about as 100% guaranteed as you're going to get with EEOC litigation. A consent decree must be approved by a judge, and it is part of the public record. There is no confidentiality post lawsuit. The terms are often very much the same, but employers need to go in eyes wide open that your opportunity to make this go away quietly is at conciliation, not in litigation. The third way that cases go away is through a negotiated settlement agreement. Now, these used to be very rare. These occur before the EEOC has made a determination. So before the EEOC says, yeah, we think you broke the law. But at some stage before that, they offer, hey, we will step back as the EEOC and let the charging party go ahead with their lawsuit. But if you want us out of the picture, give us, and it's usually a very light version of what they would be asking for in conciliation, shorter term, lighter terms in terms of what the obligations are. Employers should consider this, but should be careful that because it's not technically conciliation if you're having these negotiations. So there isn't the protection of statutory confidentiality with settlement agreement. So the EEOC tends to have a form one pager that looks really attractive, but I would invite you to talk to your in-house and external counsel on that, because there are things like no term or no geographic scope, and certainly confidentiality isn't baked in. So these are terms that you would want to add, and the EEOC can be pretty open to those. But just beware of these settlement agreements because they look good. They look like a simple way of getting rid of EEOC from the mix, and they can be effective at that, but you got to be careful on how you structure those. Finally, the EEOC can win at trial. After a jury or bench trial, they can win. And what happens in those instances is the charging party or the aggrieved party will get a certain monetary reward that's brought by the jury, but then there is a time for non-monetary relief. And James, I know you've looked into what the non-monetary relief looks like. Why don't you take it from there?
Yeah, absolutely. So once we are in this, albeit rare stage of the case where we proceeded through trial, the EEOC has achieved a favorable verdict. The EEOC will, of course, request the full gambit of non-monetary relief. They'll ask for follow the law provisions, internal practices and procedures, mandatory anti-discrimination training, things like reporting and monitoring requirements periodically throughout the decree. Our analysis here shows that most courts are not coming close to granting this full scale of requests, and that is because at this stage in the case, the judge, not the jury, is deciding on non-monetary relief. And the judge in this case will look at whether the facts indicate a danger of future violation. So if you are facing pattern or practice allegations that do get to this stage, you may be on the hook for more broad non-monetary relief. But in the vast majority of cases, employers are successfully taking the position that injunctive relief at this post-trial point should be limited to the claims at issue, things like narrow training and policy adjustments specifically related to to the claims at issue. So the scope of non-monetary relief, once we get to the post-trial stages, is typically pretty narrow.
And one interesting point to add to that, James, is that I think we're all familiar now with Project 2025, at least, or at least have heard of it. And among the wish list of items that it has under employment issues and labor issues is the idea that the EEOC should disclaim the power even to enter a consent decree that has terms in it that a court could not otherwise or that couldn't be required under the laws that it's trying to enforce. And so we might see some of their asks potentially get more in line with what you saw from your analysis of the outcomes after these things are decided by courts on the merits. Something to keep your eye on.
Yeah, absolutely. Thanks for jumping in there.
Real quick, if I could just throw in one last point on this. If you are facing EEOC litigation, I think it's important for you when you're considering who to staff on the case that they do have at least some experience with litigating against the EEOC, and in particular having trial experience with the EEOC. The EEOC does have some excellent trial lawyers out there in the field. They don't have many opportunities to go to trial, but when they do a very good job. So it's something to keep an eye on, always looking, and this is true of all private litigation as well, but you always want to keep your eye towards how this case might look at trial. You do want to think about how it's going to set up in discovery, how it's going to look on summary judgment, but trial is an important consideration, and that's particularly true with EEOC initiated litigation. So sorry, James, didn't mean to stomp on your line there.
Oh, absolutely. I appreciate you jumping in there. I think we can go ahead and move to the next slide. And here we have the EEOC strategic priorities. We've touched on throughout the presentation what the EEOC's priorities are, but can the group explain for the audience a bit about what those priorities actually look like in practice for employers?
Sure. I'll kick us off here. This is where the tea leaf reading really starts to take hold, because I think that we had a pretty good sense of what the strategic priorities were for the EEOC up until a couple of months ago. There is still in place the EEOC's strategic enforcement plan that discusses what its priorities are, and that until the EEOC has a quorum cannot be changed. But that's how much the EEOC in practice follows those strategic priorities. We will see, and we'll just walk through each of these to give you a sense of, one, what they currently are on paper, and two, what we think that they will look like under the current administration. So Sam, maybe you could start us off.
Sure. So the first priority is eliminating barriers in recruitment and hiring, excuse me. And with that, the EEOC would focus on discriminatory recruiting and hiring practices and policies under any of the statutes the EEOC enforces. So ADA, Title VII, ADEA, of course. And as I mentioned earlier, in light of Commissioner Lucas's statements about a focus on sex discrimination against women, for example, we think it's likely that the emphasis on barriers in recruitment in hiring based on sex would not include those based on gender identity and sexual orientation.
The next priority is protecting vulnerable workers. It's something that the EEOC has historically viewed itself as being particularly focused on. But what is a vulnerable population? Up until this, the last couple of months, that has historically been non-English speaking employees. It has included itinerant or migrant workforces, anyone that doesn't have a full understanding or agency to defend their civil rights. Okay. Now, how that jives with the current administration's political agenda, I have to question whether those historical protected groups are going to be getting the same attention as they did under the previous administration. Another vulnerable population that has been championed by the EEOC over the last few years is women, and particularly young women. And if I can narrow it down even more, young women in the hospitality industry. So think about teenage workers in restaurants and in hotels. Those are folks that the EEOC believes don't know their rights, or for power disparity reasons won't try to move forward with their rights. Under what we are hearing from Acting Chair Lucas, I think that that's still a group that would be protected and vigorously protected even under this administration. So what other vulnerable populations might include, sky's the limit. And looking at the political direction of this administration, it might be something that looks completely different than what we've been seeing in the decades before now. The next topic is addressing these developing issues. I'm gonna table that because we're going to do a whole discussion on that. But Sam, could you talk about the next one?
Yes, the next priority is advancing equal pay for all workers. And that would involve combating pay discrimination under the Equal Pay Act and Title VII, as well as other bases protected by anti-discrimination law. So any type of unequal pay based on age, disability, and the like. There is not a whole lot of litigation in this area to begin with, and we think that's more unlikely to increase, even though it's purportedly a priority under the enforcement plan.
Yeah, we don't see a whole lot of those, especially under the Equal Pay Act, which has a lot tougher statutory structure. If these cases are brought, they're usually tucked in under Title VII because it's an easier method of proof. The next one is preserving access to the legal system, and that's really morphed over the last few years, over the last decade, to retaliation claims. And Sam appropriately pointed out earlier, this is a real hotbed. More than 50% of the charges out there have a retaliation element. So, and this is my view. I think that it's a less politically charged when you're talking about a retaliation claim. You're not talking about protected classes and what is and is not protected by Title VII. Rather, you're talking about, I complained about something that I thought was unlawful and I was retaliated against. I think that that is something that this administration can stand behind regardless of the political climate.
And the last priority is preventing and remedying systematic harassment based on all protected categories, including sexual harassment. We do not anticipate this administration will focus on harassment based on sexual orientation and gender identity, but rather expect to focus on sexual harassment against women and other historical basis for harassment claims like race.
All right, thank you both. Our EEOC report does dive into these priorities in more detail, but as Chris mentioned, we're going to spend a bit of time talking about the third priority, which is addressing emerging and developing issues. If we can flip to the next slide, we have called out a few topics that we feel are on point here for the EEOC to focus on as emerging issues in the near future. And one of those, the first topic you'll see on the screen is pregnancy, specifically pregnancy accommodations and guidelines under the PWFA, which is the Pregnant Workers Fairness Act. Sam touched on the act before, but the PWFA was enacted in June of 2023 and essentially strengthened protections for pregnant workers and also required employers to accommodate several pregnancy-related conditions. Now, shortly after it went into effect, the EEOC issued its final rules and regulations concerning enforcement of the act. And the EEOC's rules broadly define the term pregnancy-related conditions to include any condition, circumstance, or procedure relating to any aspect of the female reproductive system, which would, of course, include termination of pregnancy. Since then, the EEOC has filed at least 5 lawsuits alleging violations of the act. As we look forward here, you know, as we've touched on, there are a few issues that are kind of falling off of the EEOC's radar under the Trump administration. But for now, pregnancy does not seem to be one of those. Acting Chair Lucas has been vocally supportive of the act. After its passage, she called it a tremendous bipartisan legislative achievement. On the other hand, when the commission voted on the final rule and regulation that I mentioned to implement the act, she voted against that rule. Acting Chair Lucas issued a statement explaining that she believes the act applies only to pregnancy and childbirth accommodations, specifically focusing on accommodation of the female sex, that is female biology and reproduction. In other words, Acting Chair Lucas disagrees with the rule's interpretation that pregnancy-related conditions should be read more broadly to include every condition, circumstance, and procedure related to the female reproductive system. So as we look ahead here, I think the bottom line for now is that while pregnancy and pregnancy accommodation issues do remain top of mind at the EEOC, it's unlikely they will enforce the act as broadly as they outlined in their regulations.
The next emerging issue is a continuing focus on the ADA. And as I mentioned earlier, the ADA has always sort of been a darling. There's consistently a lot of charges, a lot of ADA-related litigation, but we do expect a sort of new focus on mental health-related disabilities and hearing impairment-related disabilities. And in fact, earlier this week, the EEOC announced a workshop called Navigating Mental Health in the Workplace, EEO Insights for Employers. I believe this was just announced on Monday or Tuesday of this week, again, sort of highlighting the focus on mental health related disabilities. The EEOC's 2024 annual report also noted outreach efforts in the area of mental health related disabilities as well as long COVID. And with regards to hearing impairments, interestingly, in January 23, the EEOC published guidance regarding hearing disabilities in the workplace. And since that point, the Commission has filed a total of 16 ADA cases on behalf of hearing impaired employees in both fiscal years 23 and 24. Chris, what can you tell us about the use of technologies? Or excuse me, Andy, rather.
Sure. So we saw the EEOC really focusing in on artificial intelligence, particularly when Commissioner Keith Sonderling was in his role. It was a real pet issue of his. And we've seen them discuss it as well in their strategic enforcement plan, and to try to seek out cases where employers might be using technology in a way that could potentially be discriminatory. So thinking of algorithms that might sort potential applicants into, you know, potential yes or potential no based on some protected characteristic. You know, we may be seeing less of a focus on that as we move forward. That remains to be seen, but it's certainly something where the EEOC has been looking for the right test case for quite a long time. They don't seem to have found it yet. We've not seen a true AI litigation matter that was brought up. What we have seen them do is file an amicus brief in probably the most high-profile case on this issue, which is claims against Workday. But we've not yet seen the EEOC really find the right litigation matter to talk about artificial intelligence. They have issued guidance, though, which is important to employers, and that guidance can be boiled down to really the simple concept. If it's discriminatory to do it without AI, it's discriminatory to do it with AI. You have to look at the outcomes of using this tool or any given tool, and to make sure that the outcomes from its use don't single out any group for unfavorable or discriminatory treatment. One interesting point here, at the beginning of the year, the EEOC issued a fact sheet on wearable technologies and sort of warning employers that they shouldn't use these technologies in the workplace in a way that might single people out for unfair treatment. So there was discussion about, you know, the use of smart watches or monitors that might, you know, check whether somebody's getting drowsy as they perform their work. One of the first things that happened after Andrea Lucas became the acting chair is that piece of information, it was just a fact sheet, it wasn't even a formal guidance, was removed from the website. And there are other instances of guidance that also were taken down. And this actually also ties back to Sam's discussion, and really our earlier discussion about the authority of the commissioners, generally speaking. So, we talked about the lack of a quorum and how that might hamper the EEOC's activities in some areas. And one of those areas relates to the issuance of guidance or rescinding guidance. Essentially, anything that was published or approved previously by a quorum of commissioners cannot be taken away without a vote from a new quorum of commissioners. And so formal guidance that's been passed can't be taken down. But anything that was put in place by a single commissioner, like our former Commissioner Burrows, can also be removed by a single commissioner. And so Acting Chair Lucas has exercised that prerogative in order to take certain things down from the website, like the wearable technologies guidance, or to put notes on certain guidance that she can't take down, but that she wants to sort of highlight may not have the full endorsement of the EEOC right now. So we're still sort of in flux in terms of what things will, I guess, remain priorities and remain guidance by the EEOC, but this little saga with the wearable technologies fact sheet is a little insight into how things might go forward.
Yeah, interesting. Thanks, Andy. Thanks, Sam. We can go to the next slide, please, as we're moving to one of the highlights of the presentation, at least for our attorney guests, and that is the CLE code. For those on the line interested in obtaining CLE credit, the CLE code is SS4441. That is SS as in Seyfarth Shaw 4441. And as Kate mentioned earlier, you can go ahead and scan this QR code, which pulls up a CLE form for you to fill out.
And real quick, if I could, before we go to the last slide, we're getting some questions about the districts and where certain lawsuits were filed. If you take a look in the book, and we'll be sharing the slides too, the districts are enormous and they just happen to have a central office. For example, if you had a lawsuit filed in Seattle, that would be tucked up under the San Francisco office, even though they're hundreds and hundreds of miles away. So what you need to pay attention to is more what you're seeing in the geographic contours of each district office. There's lots of things, for example, that happens out of the Indianapolis office that has nothing to do with Indianapolis, and Phoenix covers a number of states, including Colorado. They have field offices here and there, but when we're talking about, for example, the Philadelphia district, it's not just Philadelphia, it's a whole region with multiple states. Sorry, I just wanted to throw that out there because I saw a couple of questions coming across on that.
Yeah, no, that's a good point. To make it even more complicated, the districts don't always go by state boundaries, so there's that to add on top of it. We can go to the next slide, please. So Andy and Chris, as we look ahead into 2025, can you tell us what employers should expect from the EEOC going forward?
Yeah, thanks, James. So I think despite all of the changes that we've seen at the EEOC in the last several weeks, and more changes that I'm sure will come, we do have to remember that most of the cases that the EEOC pursues, either through its most serious investigations or in litigation, are not necessarily on controversial issues. So we've seen in recent years a focus on claims under the Americans with Disabilities Act, and trying to ensure that employers are recognizing that covered disabilities don't just include physical disabilities, but also maybe some invisible disabilities. So we've seen a spike in charges or litigation related to ADHD, autism spectrum disorder, PTSD, different conditions like that. And I don't think we'll see a change in those kinds of litigation efforts. Similarly, we were talking earlier about harassment charges, and I think that those will continue to be a focus for the EEOC, and so long as they fit this administration's view of, of sex and sexual orientation, we'll probably still see claims related to sexual harassment, maybe racial harassment. The other thing to bear in mind is that to get to litigation, a charge has to go through a very long process. There'll typically be years of investigation from the date that the charge is filed until you wind up in court. And so, they're going to have to work through the pipeline of charges that they have right now before they can start to maybe develop other cases that fit other theories. And then the other point I would bring up is that there are quite a few cases in the pipeline that are still on court's dockets. There's obviously a lot happening at the EEOC that will be distracting to the attorneys who prosecute those cases, who are already stretched very thin, and we're likely going to see reduced budgets for litigating those cases. And all of those things may mean that there is a drag on new case filings as we go into this new year. But you have to remember that with the EEOC, it's kind of like the duck on the pond. There's a lot going on under the surface that you don't see. So while we see the litigation that appears on court dockets, and those numbers may go down, I think we'll still expect to see a large number of charges. And so employers still have to stay vigilant in complying with the laws that are enforced by the EEOC, and making sure that they don't become one of those cases that does find itself litigated in the public eye on a court docket. So, Chris, you want to talk about how folks might avoid that?
Right. Yeah, we get probably one of with all four of us, one of the questions we get asked the most is, what do we do? What do we do as employers to inoculate ourselves, or at least help mitigate the litigation risk? And I think some of this hasn't changed a whole lot. One is doing a privileged audit of your policies, practices, and data. Now, with the EEO1 litigation sort of dialed down, it might make you think, well, maybe I'll take my foot off the gas a little bit on looking at that data. But you do not want to find out that you have serious underrepresentation of any particular groups in a complaint, or when you have to produce a spreadsheet in an EEOC investigation. It's better to at least know from time to time, take that temperature, make sure it's all under the heading of privilege, but take a look at that and see where you might have vulnerabilities, see if you can make sense of why you might have those underrepresentations. It might be for a completely innocuous reason, but knowing it going in is a better position to be than finding out later and trying to have that kind of analysis and maybe even fix some of the problems that might be out there after litigation has been filed. So that's number one. Number two, training. We beat the drum of training all the time. Not only does it give you a litigation defense, but it works. It really does work. It provides employees some certainty, even in these uncertain times, of what's inbounds and what's out of bounds. The EEOC has taken sort of a broad view in the past of what that training might look like, but any training is better than no training at all. So I know that when we're creating litigation narratives, we love to be able to say that this employer takes these responsibilities seriously and they train early and often. Juries actually react well to that concept. So I would encourage you to consider training, even if it's an hour, right? It's better than nothing. And finally, and this one is maybe not as intuitive, is your internal due process mechanisms. Do you have a robust mechanism for folks to complain internally about things where they feel like it's either unfair or unlawful? And do you handle those, do you take those questions or concerns in and process them in a way that makes the employee feel heard? This feels all very touchy-feely, but let's just take out of the mix whether it's a good thing or bad thing for an employer to do. As a legal defense, it truly does minimize the amount of litigation. If an employee feels heard, they don't go to the EEOC. If an employee feels heard, they don't go to a private plaintiff's lawyer. So again, I would recommend that most employers do have some sort of mechanism in place, but make sure that you're putting the emphasis on that it deserves, because it can save you hundreds of thousands, millions in legal costs and possible vulnerability.
Thank you both. Those are excellent insights. We can go to the next slide, Kate. Before we end today, I'd just like to give a quick plug for our EEOC report. You've heard us reference it throughout the presentation. Everyone who attended today's webinar has already received a link to access the report, but if you're still looking for a copy, you can reach out to any of the speakers or go to our firm's website. It's also worth noting about the report, while so much, as we've discussed, has changed just over the last few weeks at the EEOC, the book is still an important resource as it allows us to both understand historical trends at the Commission and then also view the latest shifts at the EEOC against the baseline of what the agency has been for the last several years. Chris, do you have any last words for the group before we close up?
Yep, just as an addendum to the book, we also have our workplaceclassaction.com blog that gives you up-to-the-minute updates on everything that's happening. So I would also add that. Thank you all for attending today. Your questions were great. We didn't actually mention it as we were going along, but a lot of what we talked about today came from your questions, and they were at times brilliant ones. I don't think we got stumped on any of them, but there might be a couple that we still need to get back with you on. But thank you so much. We do this every year, but also keep an eye out for other updates from Seyfarth Shaw, and we appreciate everyone being here today. And thanks to my co-presenters and our moderator. Excellent job today. Thank you.